Good morning, everybody. I'm Mark Rogers, and sitting next to me is Roman Hoynatsky. We're the attorneys from the office that are going to answer questions today. And in a second, we'll let you know how to go ahead and ask your questions on this program. We hope a lot of you had a chance to view the segments of information that we taped on Black Friday. There were 4 different videos. The way you find them is you just try to Google Angermeier and Rogers, spell it all out, YouTube, and if you're lucky, you're going to end up on that site, and you will see those videos to look at. The segments that we did on Black Friday included a segment on planning for long-term care costs. That was done by Stacy Vogeltans. We did our usual refresher on successor trustee duties, and this year we added an additional segment in there about trust protector, and we expect that there may be some questions today about that. Amanda McCormick did the tax law update, and she talked about where the estate tax currently is and some of the proposed changes in Congress. And then Roman did a segment on when you should get a hold of us for a review, what could have changed in your life or in the law that would make you want to come in. But I can tell you one of the things that Roman talked about is the change in focus in tax law from worrying about the estate tax to now worrying about the capital gain tax and how to avoid that. So let's talk about how to ask a question in today's session. Down at the bottom of your screen, there's a bar with some icons. One is for questions, Q&A. The other is for chat. Either one will work. When you hit those buttons, then you'll be able to type your question, and then remember to hit the send button. And then our producer, Joe Minicall, will tell us that we have a question and read it to us. So that is the end of the opening remarks. Joe, do we have any questions yet?
Not just yet.
Well, so Roman and I thought this might happen. Everybody's a little shy. So what we wanted to start with today is questions that we often get and what the answer is. So the first one is going to be one I'm going to respond to and that I've heard a lot. So I'll get a question something like this from one of you. My financial advisor says I should name my children directly as the beneficiary of my IRA and not name my trust. He says that naming a trust will cause immediate taxation. So which is the better option for me? Should I, for inherited IRAs for my children, should I name the children directly or name the trust? So the answer is, it's actually good that your financial advisor was concerned about that. Trusts that are drawn correctly, meaning have the right wording in them, like ours, are going to allow you to name your trust, and then it will be seen as a thing called a see-through trust. And it will ignore the fact that there's a trust there and look to see that you have individuals named, and that will allow you the same benefits as naming your children directly in terms of the tax deferral. So there is no immediate need to withdraw the money if the trust is named, and there is a huge benefit. That benefit is asset protection. So if you name your kids directly, they get involved in a lawsuit, their IRA is going to be at risk. If your child becomes a little older and ends up needing long-term care in a facility and could get onto Medicaid, the money that is held directly will count against them. They'll have to spend it down. All this is not true if a trust is named for the child. Then there's no immediate need for spend down, and your child's both a child named directly and the trust will benefit from the 10-year rule. That means you have 10 years if you're a child to withdraw the money before you have to close up the IRA. So do we have any questions now, Joe?
Yes. In a family trust, a first death then provides lawsuit protection on all assets in trusts. Thus, I can drop the umbrella coverage at the first death, correct?
Ooh.
You have that one, Mark. Why don't you answer that?
I would I wouldn't drop the umbrella coverage. You still need to cover your own personal assets. But there is asset protection for that family trust in case you do Roman's favorite thing, which is to run a red light and hit a van full of trial lawyers. So, and usually the umbrella coverage is pretty inexpensive. So I'd rather have a belt and suspenders to hold my pants up than just a belt. And then have that one thing fail in some fashion. So it's just a matter of being conservative and safe.
And also, Mark, I think that we are seeing family trusts being used a lot less in our planning. So that if you have a case where a family trust has already been funded, there is asset protection in that family trust. But going forward, we're finding far less reasons to fund the family trust.
That's true.
For high income individuals, estate greater than 10 million, should assets be used for LTC, or can those be protected and moved to Medicaid? What is the spend down for Medicaid, again, in high value estates?
The spin down for Medicaid is the same whether you have a high value estate or not. It depends on whether you're married or single. So for single individuals, you have to get your estate under $2,000. So you can see that would be a disaster for a high net worth individual. And then you can also keep what are called exempt assets if you're single. House, a car, and a prepaid funeral are the most common things, but everything else has to go. If you're married, quite a bit more can be saved. So the general asset limit for a married couple is somewhere between 50,000 and about 130,000 that can be protected in addition to those exempt assets. So sometimes what we do with a high net worth individual is we don't try to save everything. An irrevocable trust would be useful for a personal residence, some of a brokerage account, for life insurance, where you're not tapping into the cash value. So you want to save part of the money, but you don't necessarily need to save all. And if you're a high net worth individual, it's a good idea to look into long-term care insurance.
Next question. Can you explain what a Washington will is?
You want to do that, Roman?
Okay, so a Washington will is based upon the marital property law that was in place in the state of Washington when Wisconsin started looking at having marital property law or community property law take over. So this was something that Wisconsin came later to than many states, and it went into effect in 1986. When the law went into effect, the Wisconsin legislature picked up what were good provisions from the marital property laws of the other, maybe 12 or 13 states that had it at that point. And one of them was a provision that allowed for the transfer of property upon, it's used for a married couple, either the first spouse to die or the second spouse, that can transfer property into their revocable trust without going through the probate process, so that it can be used to save the need for moving. Say if you had a home in northern Wisconsin that you forgot to put in your trust, we could use the Washington will provision to get it into your trust without having to go through the probate process. Now, we prefer to have everything funded because there's a lot of advantages to having property in the trust when the trust is set up. But if something is forgotten, the Washington will is a way to get it into your trust without having to go through probate. Now, that Washington will provision will only apply to property that's located in the state of Wisconsin. So if you bought property in Tennessee and forgot to put it in your trust, we would not be able to save a probate by using the Washington will provision. Mark, anything else on that?
Yeah, I think one other thing to know about that is because a lot of us get cold up here in Wisconsin and we find a warmer place to live during retirement years. So if you've got you're married and you have a Washington will in your marital property agreement, it will not work so well and may not work at all if you relocate to Florida or Arizona. So, and that's usually something that we'll remind you about when you're about to leave.
Can you explain rebasis? In other words, when the first spouse dies, the estate gets rebased. I take it the traditional IRAs will still be taxed as the money was saved before tax from the employer.
Okay, I think I could do that one. So the things that basis gets adjusted, we call it a step up in base because commonly over time assets, and they're called capital assets, will increase in value. And here's what those capital assets are. It's your house, a vacation property, a business, stock brokerage account that's not in an IRA. Those things, stocks and bonds and mutual funds, will all get an adjustment in basis to the value on the date of death. And again, it's usually a step up, not a step down, but there were weird years in the past. I think 2008, if people died in that year, they may have seen a step down in basis. But it's a real benefit to erase the built up capital gain. And we try to do everything we can to make sure that happens. Now, what about that IRA? Anything that's classified as income in respect of a decedent, like an IRA or an annuity, does not get a step up in basis. An IRA is 100% taxed as ordinary income as you withdraw the money. An annuity, if it's cashed out, will have some part that's taxable. It's the profit. So if you invested $50,000 in your annuity, but by the time you died, it was worth $70,000, we're going to tax the profit, which is the $20,000 gain. So those kinds of items do not get a step up in basis. And we hasten to add that assets that are held in a family trust generally will not get a step up in basis, which is why Roman and I are trying to get people in, whether a death has occurred yet or not, to realize that the family trust will not get a step up in basis, even though it protects the assets from the estate tax. But usually the exemption is big enough to protect you instead of using the family trust.
Still no questions?
Well, we're prepared for that. So here is the next question. So a lot of people call and they're confused about where tax law is because there's been so many proposals made in Congress. We don't know what's in place and what's being proposed. So here's the deal. The estate tax, which is a tax on what you're trying to transfer at the time of your death. If you transfer to your spouse, we don't worry about the estate tax because of the unlimited marital deduction. But if you're transferring to your children, so if you're the second of the spouses to die, or you're a single individual and you pass away, your estate is subject to taxation depending on how big it is. So, and that's the exemption amount. How big does your estate have to be to even worry about this tax? Currently, the exemption amount is $11,700,000. And if you're a husband and wife, you each have that same exemption. So you have twice as much. You're at about 23 million in exemption. And so the law says that in 2026, the exemption amount is going to be cut back by half. It's going to go back to 5 million indexed for inflation. And that's going to result in about a $6 million exemption. Thankfully, the exemptions are still transferable between husband and wife. Now that's what the law is now. What's being proposed is to move up the effective date of the reduction of the exemption by half from 2026 back to January 1, 2022. I think that those proposals have been stalled in Congress at this point.
Still no new questions.
Okay, now it's my chance to pick on Roman. So, Roman, my daughter got married, and no surprise, she changed her name. Should my trust be updated to her current name? Is there a problem if I don't?
So good question, Mark. And that's one I often get. And it applies not only to your trust, but it could also apply to your other estate planning documents, whether they're a will, a healthcare power of attorney, or a financial power of attorney. And the strict legal answer is that if the name that your daughter used on the date that the documents were signed was her name at that time, then those documents would still be legally valid. So she would not be disinherited because she got married and her name changed. Now, having said that, many people will want to update their plan to show the new name for their daughter. And that can be done in a trust with just a simple amendment that would just state wherever her name appears, it now shall read as her new name. Other documents, normally we can wait until other changes are being made. It might be more efficient to wait to update those just from an economic standpoint. And then the other question that comes along similar to this applies to a daughter that may get a divorce and go back to a former name. And in that case, the answer is basically the same. But for convenience, once again, people may want to update the plan to show the proper name. But legally, your daughter would be treated the same. There just might be some inconvenience of proving the name change.
Sort of a related question that I've gotten recently a couple of times is a new family starts out, they come in and get their estate plan done with the first child, and then they have other children. Do they need to come in to update their plan? And the answer is usually not, because we'll insert a provision that says that we're going to add into the plan automatically any afterborn or adopted child. So they're treated the same as your first child. It's just that if your afterborn child actually is in a position to receive an inheritance and you haven't added him or her in by name, they'll be a little irritated. They'll still get their money, but they'll be a little irritated.
And the same thing can apply. We've done plans for people where the client may say, I want 20% of my estate to be split equally by my then living grandchildren. And sometimes the client will want to name the current grandchildren. Other times they just leave that language. But the same provision would apply if the grandchild is living at the time of the appropriate death, then they would also be included at that time.
So Joe, I should have said the questions that you all may have are not limited to what was the subject matter of the Black Friday program. We're here to answer any estate planning question that any of you may have. Do we have any others, Joe?
Yeah, so this actually is a follow-up to the Black Friday program.
Right.
They said they were able to view the meeting, and when moving to another state, I believe you said we need to find a trust attorney in that state. Is that correct?
Yes, and we can help you do that. We're not going to leave that to you. Roman and I belong to an organization of estate planners that are a lot like us. They tend to be in smaller firms, not the giant firms. The organization is called Wealth Counsel, and we know people. We not only can find them by looking on the internet, but we know many of them because we pretty much every year go to a program, an annual convention, where we actually get to meet people from these different states. So it's important to get somebody in that state. Sometimes Our clients want to continue to work with us. So we have clients in Florida and Texas and Arizona that have decided that they wanted to stay with us. And we just make sure that we have somebody in that state take a look at what we've done. But usually the things that are commonly needed to be changed when you move from state to state are the financial and healthcare powers of attorney. The trust often does not have to be changed at all. But it's still a good idea to have a lawyer in that state take a look, and all the better if we can get somebody who's familiar with the type of work that we do.
Under the law, that your documents would be valid in any state that you end up residing in. But for example, the healthcare power of attorney in many states is a very specific looking document. The one that we have done for you is for the use no matter where you go, and we've had clients use it in other states. But because of this, there might be an admitting person at a hospital, when they look at the healthcare power of attorney, they may be expecting to see a specific form, and it might just make things easier going to conform your healthcare documents, especially to the type of documents that are most commonly used in the state where you're residing. So it's not that your documents become invalid because you're moving to another state in most cases. It's just for convenience of what the traditions are in that state with various ways estate planning and powers of attorney have developed.
Any others?
This one starts with creative ways to remain fair for 4 sons in gifting when 2 out of the 4 are married. My wife and I have been gifting $30,000 for each child, where I could give 2 married children $60,000, the child's wife 2 times $15,000. Do I keep track and just isolate an additional $30,000, knowing this is not gifted but remains fair for each son?
And next year you can give $16,000. The rules came out just recently. I'll take a shot at it.
All right, I will too.
Okay, so if you adhere to the principle that you want to equalize your estate by your own children. So if you have 4 children, that you want to equalize it in that fashion, then you could keep track and enter a provision in your plan that upon the final distribution of your assets, that those gifts that weren't equal would be treated as an advance. That's sort of a cumbersome way of going about it, but it would be a way that if you want to equalize it by child, you would be able to do that. I've seen clients do it both ways. Whenever they have a spouse or an in-law that they can make the gift to in order to reduce their taxable estate, they make the gift to both parties. But it's really a matter of your preference.
And my answer is what he said. That's exactly what I was going to say.
What are the advantages of setting up a trust for each child versus allowing the estate to flow through after the passing of both parents? And then parentheticals, taxes, control, etc.
So Roman and I often recommend that a client leave inheritance to a child in trust. The things it will help with, we've mentioned asset protection. And so when we interview we want to find out what your child does for a living. Is your child married or single? Does your child have health issues? What does your child's spouse do? How stable is that marriage? All those things can push us toward setting up a trust for that child. And we have lots of flexibility. We can also have issues where we're trying to protect the child from him or herself, bad impulses, poor judgment. In that case, we set the trust up and then we don't allow the child to be in control by being the trustee. They could be a co-trustee at best, but you want to have some other trusted member of the family or a professional managing the money for a child that's problematic. If the issue is health, this trust will protect from Medicaid spend down, so the child can become eligible for SSI or Medicaid and still have that fund of money that you've left them if you do it in a trust. But for a lot of people, we're able to set up a trust, and ever since 2014, Wisconsin law allows the beneficiary, your child, to be the trustee as well. And so and for purposes of just having the money, investing it, deciding when to spend it, your child is acting alone as though they had gotten the money directly, but they will still benefit from the asset protection. So those are the reasons we look into setting up a trust. There's no particular dollar figure, although we would say anywhere from $100,000 to $200,000. It's a marginal choice to pick a trust. You'd pick one if you really had a child where you were worried about a lawsuit or a divorce. And so for larger amounts, it starts to become a no-brainer to say, let's set this up as a trust. Ongoing issues with the trust, it's not too bad. Your son or daughter has to file an income tax return for the trust in addition to their own personal tax return. And they have to make sure that income from the assets in the trust don't get trapped in there with where the trust pays the tax bill instead of your son or daughter. And you fix that by making sure that money, that income gets distributed out to your son or daughter. So they'll need a little counseling, but there's generally no ongoing cost except for the preparation of that income tax return. And so then we think about both the estate tax and the capital gain, the step up in basis. And we try to, if you need to have the trust avoid estate tax for the child because the child has other assets that make them subject to the estate tax, then the trust is designed to pass from generation to generation without being subject to that tax. If, on the other hand, including the amount of the money in the inherited IRA or I'm sorry, the inherited trust at the end of that child's life, combined with his or her own assets, is not going to give them a taxable estate, then we want the step up in basis. And so Roman and I and everybody in this firm will design the trust so that we can avoid both of those taxes if possible. That was a long answer to a short question.
And I want to make it longer.
Go for it, Roman.
Okay, so a few other factors that I often like to discuss with my clients is that it doesn't have to be the same for each child. You could have ongoing trust shares for certain children, and you could have outright distributions for others. Just like the shares don't have to be equal, even though most of the time they are, the way that they receive their funds does not have to be equal either. And then another advantage of the trust, the ongoing trust share, is that if you leave ongoing trust to your child and they have, you have grandchildren through that child, something happens to that child, you can build in to your child's trust what will happen with those funds that they can go on to either your child's spouse or your child's children, your grandchildren. So there's a lot of design flexibility that we can incorporate into those lifetime trust shares for your children.
Yeah, I hasten to add, now that Roman said that you know, we do see the situation where this is why we ask about your child's spouse, and sometimes a parent will say, "There's just no way I want to see this money get to my stepdaughter or my daughter-in-law," and we explain that if you leave the money outright to your son, and then he dies, guess where the money's going to go? Right? He's married, he's going to name his spouse, that's what's going to happen. So you're absolutely going to need a trust to make sure that the money goes from your son to your grandchildren. Now I'm done.
Should a power of attorney be a person from the same state you reside, or can they be from another state?
Okay, we're gonna argue about this one a little, Mark.
Not much. You want to take a shot at it?
Okay, so Mark and I share most of the same views, and this one we tend to give out a little different advice. I generally advise that since we have good forms of communication, that you pick the best person for the specific job requirements, so that an out-of-state family member that has a healthcare background may be more appropriate for your healthcare agent than someone that lives in the same community with you that has a different profession. Same thing could be said in the financial area. If you have a CPA or a financial advisor in the family, you may want to use them for your financial advisor, even if they live in another state. All things being equal amongst the candidates for these positions, then I would default to the one that's the closest.
Now, my answer is slightly different. On healthcare, we have to name agents one at a time, and distance does matter. And Roman's right about you also want to try to get the best person, but a lot of times you just can't arrange that. The best person is out of state in Rhode Island, and you just make a decision about that. But if you've had any experience as a healthcare agent, sometimes you need to be in the emergency room to see what's going on. So that's how I feel about that. On the financial side, I'm much less concerned about distance for the reasons Roman said. But sometimes little things have to be done locally. And so one way to solve that problem is to pair up two people, one that you think has the brains or the best skill to be the agent or trustee, and the other who's local, who can run things down locally, so you can pair them up on the financial side.
Our daughter's marriage has some issues. She has just told us that her husband is entitled to 50% of inheritance if they divorce. How can we prevent this?
A trust. It's really that's not true exactly. So let's first not have a trust. So
let's presume that we're answering this for someone living in Wisconsin, because
right.
Marital property laws in different states can vary. But Mark, why don't you go on and answer if this is a Wisconsin couple?
So if it's a Wisconsin couple and they marry, and your son or daughter receives inherited property from you, they can protect that money by keeping that account separate. Generally, there's a provision in the divorce code that says that the estate is divided, but generally they will not divide inherited property. It's awarded to the individual who received it. But here's what happens. The inheritance comes in, and your son or daughter just plunks the money into a joint account with their spouse. So they've just shared half the money. But if they did keep the money separate and they passed away, that separate property is passed according to their plan. So a trust keeps that money from ever becoming marital property. So if you leave money and property in trust to your son or daughter, it doesn't become part of their marital estate.
And the other example similar to the bank account or the joint investment account may be putting an addition on a home, buying a vacation home, something like that, that in a trust we could protect But the way that husbands and wives often own property, they would take the vacation home as joint tenants, and then it would likely be divided in divorce, and it would not protect your child's inheritance in that fashion.
My parents are in Arizona and I would like to work on their long-term care planning. Would you be able to do this?
We would only be able to connect you up with somebody in Arizona. That's very state specific. So we don't know the twists and turns of Medicaid law in the state of Arizona. It's pretty similar from state to state, but there can be very significant differences between how they work. An example is in our state, Medicaid law treats as an exempt, meaning non-countable asset, the IRA of the spouse that's not going to go into a nursing home, whereas many other states will say that does count. So we actually ended up advising one client that thought they wanted to move out of Wisconsin to Illinois to be closer to a son or daughter. Don't do it, because they had a huge IRA in the hands of the healthier spouse. So what we would do, we know people. We're also a member of a group called Elder Council, and it's like Wealth Council. That we know people in these other states, and we can make a referral to somebody good down in Arizona to help you.
Since we funded our trust, we have obtained some additional assets, namely an antique auto, plus a garage full of tools and equipment. None of this is currently reflected in our trust. Estimated value of these things is around $60,000. Do we need to add them into our trust? If so, what is the process?
Probably two different answers here too.
Well, as far as the tools and equipment, the assignment that you signed when you set up your trust would cover after acquired property. Now, so I think as far as those items are concerned, they'd be covered, they'd be in your trust. Now, if you have a specific beneficiary that you want to receive those things, then you could use the pages at the end of your trust binder and name recipient for those items upon your death. If you don't name a specific recipient, then they would be distributed according to the other provisions of your plan. Now, on the antique car, depending on the value of the car, that would influence whether Mark and I would advise you to get that titled in the name of your trust. Putting a collector vehicle into a trust can be a little bit challenging. There's pictures that are required, and we have done this for several clients. But I would again say that depending on the value of that car, that would be the one thing that we would want to give specific advice on.
Yes, what he said. Joe, I'm wondering if we are recording this segment, and Joe says yes, we are. So if we seem to have gone by answers pretty quickly and you couldn't get good notes, we will post this on that same YouTube website so that you can take a look.
Ready for the next question?
Yes.
Should the beneficiary of our 401ks be the trust or our spouse?
Mark?
It depends, but most of the time we're going to recommend that the spouse is the primary beneficiary and the trust is the contingent beneficiary. It would be a pretty unusual case where we would say, let's name the trust primary. That would be a situation where for one reason or another, we wanted to leave money in trust to our spouse to protect it in case he or she remarries, and to make sure it goes down, for example, if it's a blended family, to my kids as the person that had the account. But again, let's not confuse you. Generally, we're going to say name the spouse primary and the trust contingent. were said.
On the YouTube prep, there was a discussion of speaking with the trust attorney upon the first death. Can you run through typically communication upon first death? Assume one bank account, one brokerage account, one home, children.
Okay.
Well, it's gonna depend on your trust design as to how much work is gonna be needed upon the first death. It sounds like that's a very well-organized estate, and a lot of work should not be needed. But if the trust was set up many years ago when we were more concerned about the estate tax than we are now, it may have called for the mandatory funding of a family trust. So even though it's a simple plan based upon assets, there may have been certain things that needed to happen based upon your estate plan. So that is why we really like you to come in and have a review, because that should be a very simple plan to administer upon a death.
So let me answer the question a different way. I'm not sure that that question wasn't about what's going to happen. What if you call in and say my spouse has passed away? What do I do? We're going to set up a 1-hour phone call, and usually Roman and I are both on that call. And before the call, just so we can figure out what the right thing to do for you is, we want to find out what was owned and how it was owned. And we also need to do the other thing, which is to look at the trust. What does it say? And a lot of times, as Roman said, we see it was drafted in 2007 when the estate tax was completely different than it is today. And it's just not an appropriate way to handle it. For many of you, we've already converted you over to and then we would expect little or no work would have to be done. So it really depends on the circumstances. But as Roman said, it doesn't hurt to get in for a review before that event happens, before that first death occurs.
Should the beneficiary, oh, sorry, was that all right? In one of the videos, you were discussing irrevocable trusts that are in stock account, parentheses, kid trust, that those stocks should be liquidated before distribution. Is it possible or beneficial to just transfer the stocks into the beneficiary's account rather than liquidating?
Answer yes. The deal there is the trust always allows the option of a transfer in kind or in cash. And so it's a conversation Roman and I will have with the individuals. Do you want the stocks, bonds, and mutual funds as they are, or would you prefer to liquidate them? The liquidation discussion also has to do with the time period. It's going to take Roman and I 4 to 6 months to wind up an estate. And on the date of death, the stocks and bonds are valued at a certain level. And stocks, generally, they've been going up, but they do go down. And so the trustee is responsible for making sure that the investments are safe and that the beneficiaries are on board with either holding the money as it is in stocks and bonds and riding along with the market, or liquidating the money so that it's safe and a stable number. So there's all kinds of issues that come around that. But yes, you can transfer stock just as it is into a kid's trust or into a kid's name.
There are some unique assets, real estate investment trusts, certain bonds that can't be split, but in most cases, an in-kind transfer will be available.
Are there trusts specifically designed for special needs children or as the beneficiary of the trust?
Answer yes. So that's one of the reasons we interview you about your kids and their health. If we think that a child is already on a benefit program or is possibly headed there, we may recommend a special needs trust. Special needs trusts are basically purely discretionary trusts where your son or daughter who has the special needs will not serve as trustee. We have to have somebody else do that. And then it'll have provisions that will suggest different ways that the money can be applied for the benefit of your son or daughter without causing them to lose eligibility for things like SSI or Medicaid. So yes, a special needs trust is a special, is a particular item that we would consider. It can be done, it can be set up if you want to make gifts during lifetime, or typically it will be put into the plan as how that child's share gets to him or her when both parents are dead.
Speaking of which, if you gift money up to $15,000 or $16,000 next year to children, what are the tax implications for us and for our children?
Well, the tax implications for you are that you're not going to have to file a gift tax return as long as the gift is under that amount. And once the funds are transferred, then the way that your children invest them, if they generate income, once they receive the gift, then they would report that income as theirs on their own tax returns.
And and just to understand the gift tax, it's a tax on the giver, not the receiver. So a lot of parents ask us, is this money that I'm going to give to my son or daughter going to be taxed to them when they receive it? The answer is no. And the person that worries about whether they have to file a gift tax return or not is going to be you, the parent, making the gift.
How often should we schedule a review of our trust? 3 years, 5 years?
It depends. It depends on where you are, at what stage of life, and whether what events may have occurred since your last review or when your plan was initially set up. So barring any other issues in your life that may require a more frequent review, a change in health, going from full-time work to retirement, things of that nature, we use as a rule of thumb 3 to 5 years, just to make sure that you don't go past that time period without touching base with us. Now, normally, as you get older, it goes to the shorter period of time rather than the longer period of time. Many times, 5 years may be sufficient for a couple in their 30s and 40s, but as you get to retirement age and in retirement, you may want to touch base with us closer to every 3 years if other things aren't bringing about a need for a review.
And please remember, there's no charge for us to take a look. And so when in doubt, place a call. Sometimes the call can be as short as 10 or 15 minutes. But if you need a real review, that might take about an hour. But again, there's no charge for that. And so it's better to be safe than sorry.
If single, 401ks should be left to trust or kids?
That was my sample question. Generally, it depends on how large or small that account is. So if it's a pretty small account, it may be simpler and easier to name the kids directly. But if you're starting to get into a couple $100,000 per kid, you're going to want to set it up as an inherited IRA that pays in to the child's trust. They'll have 10 years to withdraw the money from the day you died. And during that 10-year period, until they withdraw that money, it is protected from the outside world. If it's left directly to the child, it's subject to the claims of his or her creditors, Medicaid spend down, division, and a divorce.
So I think, Joe, the question started as a 401k question. So we would be able to assist you in getting the funds rolled over from a 401k into, normally it would be a type of IRA that then you would be able to control, because most of the employers want to have you have those funds move out of the 401k program after a death. So that's something that will accomplish the same benefit, but there will be an additional step to move those assets.
That's right.
Can you explain the differences between the trustee of the initial trust and the trustees of the created children's trust?
Well, in there's various stages when we design the trust, so that you can select the most appropriate trustee to succeed in any circumstance. So in the case of a married couple, normally if one of the couple is unable to transact business, then the well spouse will take over. And if they both can't, or there's been a death, and on the second death, there's a list of people that'll take over. Their purpose is to pool the assets and to administer the estate. At the time that it's distributed, if you could actually use the same trustee to oversee the assets for the trust shares that are set up for the children or grandchildren. But because of the flexibility in which we design trusts, you can select the best trustee for each one of those inherited trust shares, so that you have the utmost flexibility in deciding who would be the best trustee for each beneficiary. And we can help advise you on that.
Let me give you an extreme example. So let's say we've got a family with 8 children. We're not gonna, and they're all pretty capable. We're gonna pick the 1 or 2 most capable to wind up your estate. So their job is to work with the lawyer, gather the assets, liquidate the assets that need to be liquidated, do the tax work, working with the lawyer, and then distribute the estate in the equal shares, and it may go into a trust for each child. So you're gonna have 1 or 2 people doing that work, but then now that the trusts have been set up, now it's Bill's trust. Is Bill perfectly okay to manage this trust as the trustee? Then we'll let each of the children manage their own trust. So it just depends on what we're having the trustee do.
Does my revocable trust protect assets if my spouse has to live in a long-term care facility? I do have long-term care.
The answer is no. Generally, no. A revocable trust is seen as an available asset. It's considered your money. There is, I hasten to add, there's one big exception to that. When somebody gets onto Medicaid, long-term care, not using long-term care insurance, they get onto Medicaid, and it could be a married couple. Once the second person dies, the state would like its money back. So the term for that is it's called estate recovery. And so there was, when the law was passed that said we're going to start going after all the remaining money that's left in the estate. Usually that was the house, by the way. The house was left because it was an exempt asset when I applied for Medicaid, but now that I'm deceased, the state is going to want to get whatever it can out of that house. If the house is owned by a revocable trust created before August 1, 2014, it's exempt from estate recovery. So that's, but the general rule is any assets I've got, we're going to ignore the fact that it's in a revocable trust. And if it's a house, it's exempt. If it's my bank account, it's not exempt. And so the revocable trust does not provide that protection. An irrevocable trust will provide that protection. And that's sometimes what we do to protect a house from the estate recovery issue if we don't have a revocable trust that was set up before August 1, 2014. Hope that helped.
Earlier, Roman mentioned the gifting strategy changing to 60,000 a year from 30,000 a year for a child and spouse. Can you elaborate?
I think I may have misspoke. It's 15,000 per person this year, and it's going to 16,000 as of January 1st of next year. And so that is per person that you can make those gifts.
So he was also talking about doubling that. So if your son or daughter is married, you can say, I'm giving 15,000 to my son and 15,000 to his wife, and then make a $30,000 gift.
And then your spouse could also make a $30,000 gift. So then that would be how we would get to $60,000.
Exactly.
So maybe I didn't misspeak.
Thank you, George Bush.
What is the significant differences between a family trust and a survivor's trust? And do they exist at the same time, but for different purposes?
The answer is yes, they do exist at the same time for different purposes. A family trust is used by the first of two spouses to die to put his or her money in a protective trust that protects from unnecessary estate tax when the second spouse dies. So that family trust is for the benefit of, it's a way of me giving my money to my spouse where she can use and access that money during her life. But at the time of her death, it will come down to our kids without being taxed in her estate. Because the estate tax exemption has gotten so big, most of the time we don't need that family trust. And it has a real downside. The downside is that unlike the survivor's trust, when that money comes at the next death down to the kids, the family trust assets will not get a step up in basis, but the assets in the survivor's trust will. And there's a slight difference between the control, use, and enjoyment of the two trusts for that surviving spouse. The surviving spouse can use the family trust for health, education, maintenance, and support. Often provisions will be in there that permit him or her to share the money with other children and grandchildren in the family. The survivor's trust is just, there's not limited to health, education, maintenance, and support, which by the way is not much of a limit. So you can do the wild and crazy things in addition to health, education, maintenance, and support out of the family trust or out of the survivor's trust. And the survivor's trust is usually amendable and revocable, whereas the family trust is an irrevocable trust. So those are the major differences between those two types of trusts.
That is all the questions we have right now, and it is 10:59.
Perfect timing. Thank all of you. Again, let me remind you about how you can find the presentation if you weren't able to dig it up. Just literally type, you don't have to put uppercase and lowercase, just type Angermeier and space A-N-D Rogers and then the word YouTube, Y-O-U-T-U-B-E, and you will be offered a chance to click a link to the website and take a look at any of the things that we posted up there. And this will be posted about how soon, Joe?
Within the week.
Within a week, this question and answer session will be there. And Roman and I want to thank all of you you had great questions today. So we really appreciate it. And I know we had some technical difficulties getting you the link and telling you how this program was going to work, but you all did great.